In this video, I'll explain to you a basic cross-examination method. You haven't been able to settle the case and the other party wants to go to trial. You've got no other option, you are going to have to cross-examine. Cross-examination is an essential element of the trial process, and you must cross-examine those witnesses that present evidence contrary to your case. In this video, I'm going to give you a basic cross-examination method. I'm going to explain to you a basic cross-examination method.
No, it's possible Travis grabbed the knife first.
You never told us that he had any knife there, did you?
No, I wasn't asked.
If you're a seasoned litigator, don't watch this video. It's not for you. This video is for someone who has to potentially represent themselves, has never cross-examined before, and doesn't have the time to read The Art of Cross-Examination.
You could have called for help on your radio, and you could have had the cavalry there in 2 minutes.
I could have.
You could have had SWAT mobilized.
They could have.
The basic cross-examination method consists of 6 rules. The first rule is win the case with the evidence and not with cross-examination. So essentially, don't rely on cross-examination to win the case. You must present to the court the evidence to support your case, and you can't rely on a stellar cross-examination to win the case. You've all seen the movie A Few Good Men, where Tom Cruise gives that dynamite cross-examination of Jack Nicholson.
Colonel Jessup, did you order the code red?
You don't have to answer that question.
I'll answer the question. You want answers? I think I'm entitled. You want answers? I want the truth! You can't handle the truth!
Well, it doesn't work like that in real life. And all Jack Nicholson had to say was, I did not order the code red, and that would have been the end of the case. So you must present the evidence, and cross-examination will not win the case. The second rule is know your case. Know your case backwards and forwards, inside and out. So you have to have read all the affidavits a number of times, and you must have examined the evidence a number of times. Don't leave your preparation to the last minute. Cross-examination is all about preparation. And if you don't spend the time in preparation and you leave it to the last minute, you won't be able to cross-examine effectively. The third rule is cross-examine only in relation to the issues in dispute. You should not cross-examine in relation to issues that are agreed. An examination of the case and potentially discussion with the other party will identify what issues are in dispute and what evidence in relation to those issues is in dispute, and you've got to focus your cross-examination on those. Don't annoy the judge or bore the judge cross-examining about matters that are agreed. In fact, in the family court, generally the judges will pull you up. The fourth rule is ask leading questions only. A leading question is a question that is closed and elicits a yes/no answer. And a simple way to ask a leading question is to state your proposition and then add something like, isn't that true, or isn't that correct, isn't that so? For example, you pushed your wife down the stairs, isn't that true? Right, that's a leading question. So basically take what you want to prove and add to the end of it, isn't it or isn't it true? Obviously that can get boring and a bit repetitive. There are other ways to ask leading questions, but this is a very basic cross-examination method. Don't ask open questions, which are your when, where, how, what and why questions. Don't ask them. Never do it. Keep your questions closed and leading.
So you're inside this closet, right?
Yes.
And you're ahead of him, aren't you? In other words, he's on the other side of the door, right?
That was my thought. I also
Ma'am,
had
I'm
fear
not
that-
asking you what your thinking was. I'm asking you, isn't it true that he was outside of the door?
Well, I don't know where he was. I just
Well,
know that I
okay,
shut the door.
then he was somewhere in the bedroom then, right?
I don't know. He could have been in the bedroom or running down the hallway to meet me at the other end of the door.
Bottom line, he wasn't in the closet with you, is what you're telling us, right?
Yes, that's right.
And you don't know what he's doing during this period of time that he's out there, right?
The fifth rule of the basic cross-examination method is close off the exits. What I mean by that is build up the cross-examination. Don't ask the main proposition first. What you should do is identify some sub-propositions which you need to establish first, or sub-facts which need to be established first and which may not be necessarily in dispute, and ask a number of questions around those sub-propositions first. Get affirmative answers to those questions and then put the questions regarding the final proposition. So, for example, if your final proposition is the witness pushed his wife down the stairs, then you might ask some questions about whether the witness was in the house, establishing that the witness was in the house, number one. Number two, you might ask some questions establishing that the witness was at the top of the staircase. Number three, you might ask some questions that the witness and his wife were having an argument. Number four, you might ask some questions about the insurance policy that the witness had taken out 2 weeks prior. So you have to ask questions that build up or close off the exits to the final proposition. The sixth rule of the basic cross-examination method is to put your case to the witness. You may have watched Geary Nell's cross-examination of Oscar Pretorius and the other witnesses in the Oscar Pretorius trial, and be familiar with his questioning method where he would say, words to the effect of, "I put it to you." And that's, in my opinion, a very cumbersome way to put the questions. It can be effective, but in my opinion, it usually alerts the witness that you're going to put an important question, and rather than just putting the question. So putting the case to the witness does not mean you have to use that phrase, I put this to you. It just means you have to ask questions about your case and give the witness an opportunity to respond to your case. It's a very important part of cross-examination. So that's the basic cross-examination method and the 6 rules. If it's your first go at cross-examination, I recommend that you at least take some legal advice in terms of your preparation and potentially getting a lawyer to critique your cross-examination, which wouldn't be too costly in my opinion, rather than just going in potentially cold turkey. Obviously, if you can afford a lawyer, that's always the best. If you can afford a barrister, that's even better. But if you have to go it alone, if you follow these rules of the basic cross-examination method, and put in the time, you should be able to develop a good cross-examination in relation to each of the witnesses.